the property disclosure statement for the new construction. And today we're going to cover the addendum to RPA. Okay. Now so I suppose everyone is using the new platform now. They kind of forces me to use a new platform. Actually, there's some good things in the new platform. Apparently, there is some improvement on the new platform. New construction addendum to RPA used when selling a newly constructed completed home. So it's just an addendum to the RPA for new construction, amongst which there is a provision on maintenance recommendation. Usually the builder will have a maintenance recommendation for the buyer. So you are just letting the buyer know that along with the purchase agreement, they are given copies of the builder maintenance and preventative maintenance recommendations. And then on the manufactured products maintenance and limited warranties, the limited warranties will also be provided to the buyer. So the builder will receive limited warranties from the suppliers for all the materials that are used, not all, but for some of the materials that are used on the project. So those limited warranties are actually transferred to the buyer. And then the builder also have limited contractual warranties. The owner, who may or may not be the builder. So the owner of the property can actually hire a builder to build the project. And then when they sign a contract with the builder, they will require the builder to provide certain warranties for the homes. So this is just to let the buyer know that these warranties from the builders are transferred to the buyer, okay? So that's part of the addenda to the RPA. And then he also describes in the event of any construction defects. If you have a construction defect on a new home, you are not allowed to immediately go to the court to sue the builder. The reason is there's a law in California that says you have to give the builder a chance to fix the problem, okay? There is a law on that. It's called the SB 800. SB 800. Later on, it is written into law as Civil Code 895, okay? What the Civil Code 895 says, it says California law establishes procedures that must be followed prior to the filing of any action related to a claimed construction defect. Now, let's say, for example, I own a home, a brand new. I bought a home about 3 years ago, and in my backyard, I have my house is on a slope. My backyard is actually sloping backyard, and it has a sprinkler system and everything. And so we kept noticing that there's constantly a wet spot on the slope. At first, we thought there was a leak from the sprinkler system. So what we did was we turned off the sprinkler system. And after we turn it off, such that no water is going into the sprinkler system, we still notice that wet spot. And it's always the same spot, okay? So what we did was we talked to our gardener. We said, do you know where the water is coming from on a wet spot? He said, let me dig. So he started digging. And then he said, that's not from the sprinkler system. It's from the ground, okay? Now, when you get a problem like that, all right, you ask, is the builder responsible or developer responsible? You as a buyer are certainly not responsible for something like this. You did not build this thing, right? And actually, before the builder will build your home, right, they usually have some kind of geological study already. They're supposed to investigate the geology before they build, right? If that's going to be a problem, it should have been discovered at that time. So it could be that the engineering company that the builder hired missed it. Or it could be that it is a new problem that at the time they prepared the report, they could not have discovered it. Whatever may be the reason, okay, it could be that the builder is responsible for it, or it could be that the builder is not responsible for it. But you're not allowed to go to court to sue the builder immediately. So you are allowed to do what? You are required to go through a process. And that process is contained within Civil Code 895. There's a bunch of things you have to do. You have to complete all these procedures, and if you still do not get your repair done, then you can sue the developer, okay, the seller who sold you the new home. That is what we call Civil Code 895. So what are you supposed to do? First of all, you're supposed to go to their website, file your claim, and then you're supposed to make arrangement for them to come onto your property to investigate, and then you're supposed to let them have time to prepare a report. After they prepare the report, and if they want to fix it, you are supposed to allow them to try to fix it. And after they fix it and it's completely fixed, then you cannot sue them. Even though this has caused you inconvenience, California law says you got to give the builder a chance to fix it. All right? Unless there was fraud by the builder, this procedure does not cover fraud, of course. If there's fraud by the builder, then you don't have to follow this procedure. You can immediately sue the builder. But if there's no fraud by the builder, all it is just a typical construction defect. You follow this procedure. Okay? Now, we don't have time to go through the entire procedures, but I just want to let you know, in the event that in the future one of your buyers actually bought a new home, they have issues with the builder, you have to educate your buyer and tell your buyer that there is a procedure in California. You cannot simply go to court and sue the builder. Okay? Now, what happens if you go to court and sue the builder? The builder can easily tell the court to dismiss your case because you didn't go through that procedure first. Now, if the builder still did not fix it after you give them an opportunity, then you can go to court and sue them. Okay? All right? So that's what this one is all about. Actions on construction defects and escrow instruction. Now, what does the escrow instruction say? It says, by signing this document, the parties are instructing escrow holder to insert in the deed, transferring the property, the language specified in quotes in paragraph 4A above. So even the deed will say something like that. Normally, on your grant deed, you do not have this type of language unless you're buying a new home. When you buy a new home, the deed may contain this language so that each subsequent buyer that owns the property, who is not the original buyer, would have to comply with these procedures before they can sue the builder. Okay? It says here, what does it say? It says, attached to the agreement is a copy of the California Civil Code, 895 to 945.5. So they are basically attaching the whole Civil Code. So when you prepare the RPA, don't forget the Civil Code, okay? If you don't have it, I can give it to you, but you're supposed to attach the Civil Code. Because the purpose of the Civil Code is to let the buyer know that if you have a construction defect, you have to follow these procedures to get the defects fixed. Okay. It says, note, realtors may obtain a PDF version of California Civil Code 895 to 945.5 at CAR. You can go to CAR website, okay, and get this particular publication. So you don't have to get them from me. Just go to the CAR website, okay, on the standard forms page of the legal section, okay. So just go to CAR and get it from CAR, okay, whatever you need for this particular type of contract, 895 to 945.5. By initialing here, the buyer and seller acknowledge that each has read and understands this paragraph and a copy of Civil Code 895 to 945.5 provided. So you need to have your buyer initial here, okay? Both the buyer and the seller has to initial it here, okay? Non-adversarial procedure of California Civil Code. Seller elects to engage in or opt out of the non-adversarial procedure set forth in Civil Code 914 for construction defect claims. Now, what does that mean? If you're a seller, would you rather have the opportunity to fix the construction defects before the buyer sues you, or would you rather opt out of the procedures and let the buyer sue you without going through the procedures? Well, that's totally up to you, okay? Now, if you represent the seller, if I represent the seller, my advice to the seller is go for the non-adversarial procedures and get it fixed. Of course, the disadvantage is that these buyers are going to call you on little things and ask you to start fixing a lot of stuff. Whereas if you opt out of it, they have to go to court to get things fixed. Sometimes if the items are too small, they don't want to spend money on attorney's fees to get it fixed, so you don't have to do anything, right? But that's totally up to the seller, though, okay? So do you mind being bothered? Now, companies like Toll Brothers or the big companies, they have the whole team, so they don't care. If you have even minor problem, you contact them. You still go through the procedures, though, right? You contact them and have to come out, send people. They don't mind that. The big companies don't want you to sue them. They would prefer that you go through the non-adversarial procedures. Whereas the small-time developer, they do care because they don't have a team. Remember, if this person is an owner and he hires a contractor, general contractor, who hires his sub, if there's a problem, you know how many layers you have to go through to get somebody to fix something, right? So I think if you're like a small-time developer, they may decide to opt out of it. Opt-in creates a lot of headache, right? Okay. Documentation to subsequent purchaser. Buyer is instructed to give any subsequent purchase of the property all documents related to the sale and purchase that the buyer receives from the seller. So this is a contractual obligation. Basically, the buyer agrees that if the buyer ever sells this property to someone else again, the buyer is required to provide all of the documentation that the seller has previously provided to the buyer, to the new buyer, okay? Agent for notice, claims and requests for information related to construction defect may be made to the following person at the following address. Now, if you are the builder or the buyer or seller, you need to provide an address for the buyer to communicate with the seller in case of any construction defects that they want to have fixed, okay? So make sure you put that information here. Documentation to subsequent purchaser, I just mentioned that. Mediation and arbitration. Paragraph 22A and B of the agreement are modified as follows. Unless otherwise agreed in a separate written agreement signed by buyer and seller, Buyer and seller agree that the procedure set forth in Title 7, subdivision of Division 2 of the California Civil Code commencing with 895 shall apply to any construction defect disputes relating to the property prior to any mediation or arbitration that may otherwise be required by the agreement. What that means is, you know, in your typical RPA, they have the mediation clause and they also have the arbitration clause. Before you even go to mediation or arbitration, you have to go through these procedures specified by Civil Code 895. Okay, so never mind the mediation and arbitration; those come later. Now, if you're not successful in resolving the repairs, then you can go to mediation. And if you're not successful with mediation, you can go to arbitration. Now, for those of you who you don't know what a mediation is, mediation, when there's a dispute between two parties, right? You hire like a middle person, somebody who's like a neutral, who's going to help the two people settle, right? Without filing lawsuits against each other. We call that mediation. All right, but on the other hand, if you're not successful in mediation, both parties still want to resolve that dispute. The next step is arbitration. For arbitration, there's a winner and a loser. Mediation, there's no winner or loser. It's either you have a settlement or you have no settlement, okay? So arbitration is the next step after mediation, okay? All right, so we are...
Mediation first and then...
Correct. If you don't follow, there are penalties, okay? All right, there's the... Okay, so there's one other form I want to show you, and which is a quick one, which is the notice of, actually, you know what, the upgrades, options and upgrades. For new homes, typically you have a need to upgrade or you need to have options though. Now, just quickly on this form, if you ever have a buyer who's buying a new home that negotiated an upgrade with the builder or an upgrade or an option with the builder, you want to use this form, and there's a place for you to list out all the options and upgrades over here and the price, okay? And then the amount, okay? And both the buyer and the seller will sign this. It's like an addendum. Actually, it is an addendum to the new construction RPA. If you ever have a buyer that buys new home, sometimes you may need to educate them. If they sign an option or upgrade agreement with the builder, and if for whatever reason the builder allows them to get their deposit back, most builders do not allow you to get your option money back or upgrade back if they have finished the construction, okay? Just bear that in mind. Even if they let you have your deposit back, you will not get back your deposit for the option or upgrade. Just the initial EMD, the earnest money deposit. Okay. All right, next one. The next one we're going to talk about is residential purchase agreement. That's what RPA stands for. Okay. And the last one is actually the notice of completion. Okay. There are a couple of things important about notice of completion. I need to educate you on those, which is that, did you know that in California, the builder has up to 2 years to deliver your home from the time you sign the purchase contract? 2 years maximum. Question is, are you willing to wait 2 years? Even if they delay for 2 years, they don't pay you anything. But of course, you wouldn't mind if your property increases in value, right? Did you know that when I bought my new home in Brisbane, I had to wait almost 2 years? I signed my contract, when did I sign my contract? I think it was like August or maybe October of 2012. I closed escrow April of 2014. But of course, I wouldn't mind because it was going up in value, right? But on the other hand, I could wait though, but not every buyer could wait. But by law, they have up to 2 years for delay. They can have any kind of delay, all right? But you know what? Most builders are kind of nice if the home prices are going up in value. Now, let's say, for example, in my case, why was there such a long delay? Because as they are drilling, it's on the mountain, right? As they are drilling, they hit some really tough granite, very hard drilling. Because of that, there was a long delay, okay? And at that time, they gave me an option. You want to cancel or not? Of course, I wasn't going to cancel. Now, if you try to ask for compensation, they don't compensate you, okay? But they allow you to cancel and get your money back. I wasn't going to cancel, though, because I know home prices were going up. So I kind of kept it and stayed with it. And it was very satisfying because the home value did go up a lot, okay?
It should be a strong house.
Yeah, much stronger foundation, so that's also good. Yeah. Okay, so just to let you know, okay, 2 years maximum, okay, 2 years. All right. And notice the completion. Basically, when you sign a RPA with most,
Only the booking amount.
that's right,
That's it.
that's right. And then at the end, you pay the rest of it. So the booking amount is like what, 3%, 3 to 5, or something like that. I can't remember, but it was really good deal. Yeah, I like it. Okay. Okay, anyway, so this is a notice of completion. It's not the same notice of completion that we talked about concerning mechanics lien, okay? This is totally different. Now, this notice of completion basically to notify the buyer when to close escrow. Typically, in the RPA with the builder, the RPA will say the builder will give the buyer, you know what most RPA will say on new home? The builder only give you 15 days to close from the time they notify you of completion. Okay. All right. So this is actually the formal notice. They tell you when they receive the certificate of occupancy, and then they tell you when you're supposed to close the escrow. That's according to the contract, but most contracts give you very little bit of time. 15 days is quite common. Okay. All right. So that's it for today's training. Next week.